So now let us start our module number 3. What is module number 3, sir? Other laws. So let us see what are the topics which are there in other laws. So obviously LLP Act is not a other law. LLP Act is a corporate law, sir. So what you will be doing, sir? Ek bar just come to your notebook, sir, and write down the contents which you have to study, sir. Write down heading as other laws. Heading is other laws. Okay. So three topics are there in other laws, sir. So write down, sir. First law which we have to read is the General Clauses Act 1897. The General Clauses Act 1897. Bracket may write down, sir. Weightage is somewhere around 10 to 12 marks. And this is given by ICI itself. The General Clauses Act 1897, bracket में 10 to 12 marks. Then we have something called interpretation of statutes. Interpretation of statutes. Statute, in fact. Interpretation of statute. There we have 8 to 9 marks in exam, sir. And then we have FEMA, which is 9 to 12 marks in exam. If at all we want simplicity, so you can understand every chapter is coming for an average of 10 marks. Okay, that is a clarity you should have. Now, sir, corporate law and other law, this paper itself is very, very vast. You might have seen that ICA has given you 3 modules and 3 books they have given you, sir. But if at all really somebody applies brain, 70 marks is what you are getting for Companies Act and LLP. Sir, Companies Act may somewhere around 160 sections are there for your syllabus. 160 sections is not a joke. Plus LLP Act with rules. That entire thing, one side if you read, you get 70 marks. Plus if you read these 3 topics, you are getting 30 marks, sir. So as an intelligent people, sir, obviously while reading, we will read in a proper manner only, sir. Once the syllabus is over, your first focus should be on completing other laws. 30 marks you have to put it in the pocket, sir. Reason is, if you see the content wise in our textbook, sir, 90 pages are there. And if at all I remove unnecessary diagrams, unnecessary content, sir, hardly you will be having 50 to 60 pages in our textbook, sir. 60 pages may you will be covering your entire 30 marks, whereas somewhere around 400 to 450 pages, you will be covering only 70 marks, sir. I'm not saying ignore that, but can I say sometimes you have to do your ABC analysis. Costing studied, no. Pareto analysis, sir. So 80-20 rule you have to apply. Definitely this you have to give utmost focus, sir. So first, for 2 to 3 days may, once the portion is over, 2 to 3 days may you complete your other laws and then come to your company law and LLP law, sir. Okay. Now, how our approach will be, sir? Sir, if at all somebody asks me, sir, chapter number 1 and chapter number 2, these 2 chapters are generally having one common objective. What is the common objective? Ki whenever lawmaker is writing any law, whenever lawmakers, now when I use a word lawmakers, here lawmakers are nothing but parliament. So I have this habit of using a word lawmakers, but whenever I use a word lawmakers, you should understand that I wanted to talk about parliament, sir. So whenever any law is passed in parliament, sir, so definitely when law is passed, so can I say the people who are drafting the law, they are having some intention. What do you mean by intention, sir? Ki mind mein something is there, you want to achieve that, for that only they have written the law, sir. But don't you think sometimes what is there in our mind and what we put on the paper, do you think every time it will match, or sometimes it may not match? Sometimes it may not match. Reason, what we wanted to tell and what we told, sir, it could be different, sir. In other words, what legislature is thinking and what you are thinking while reading the law, it can be different, sir. For example, sir, can I say whenever any dispute comes to the court, can I say it is a judge who has to now pass his judgment, sir? Can I say obviously plaintiff side you will be having an advocate, defendant side you will be having an advocate, sir. Both people will give their point of view, yes or no? So plaintiff ka advocate will tell, Judge Saab, you have to read law in this manner. Defendant ka advocate will tell, no, you have to read law in this manner. In other words, are they both reading the law in the manner in which legislature wanted to read? No. Why? Sir, logic is very simple. Even the lawmakers who are preparing the law, they are also humans only. Yes or no? And is it possible that precisely you can write everything, sir? Answer is no. Nobody can write precisely. In fact, English language itself is complicated. And that too, we are writing law in which language? English language, sir. So sometimes what we wanted to tell and what we wrote may not match. Sir, if at all such type of problem occurs, so do you think the objective of the law will be achieved or will not be achieved? Will not be achieved, sir. Then as a situation, what should we do? Sir, judge has to plug the loophole. Now what should judge do? Judge has to understand the intention of whom? Lawmakers. Whatever lawmakers thought, what was there in their hidayam, in their hearts, who has to understand first? Lawmakers. That is nothing but judge has to understand that. And after understanding, sir, he has to provide his point of view, sir. Sir, to understand the intention of lawmakers and to provide the point of view, you have to use some tools. And those tools are provided by which chapter? General Clauses Act and interpretation of statutes. In other words, these are the two laws which helps you in reading and understanding the law properly. For example, sir, can I say, how many of you are from foundation background? Okay, 2-3 people are from foundation background. Okay. Sir, if at all we have studied Contract Act properly, sir, you will be observing that total Contract Act mein everywhere the gender which was used was masculine. They never use the word she. They only use the word he. Wow. That means if there is a breach of contract, he shall be. Matlab, these are the problems or these are the remedies which he can claim, sir. So now my question to you people is, tomorrow if there is any female who is having a breach of contract and if she wants to go to the court and ask for remedy, will judge say that, Chinti, law may only which word is used? He word is used. You are she. Hence, this law is not meant for you, sir. Do you think judge is going to tell this thing, sir? Sir, wo bhi chhod do, sir. What we will do is, I will just show you your Companies Act itself, sir. So, Companies Act mein, we will see something called section number 164. Now, section number 164 is not there in our syllabus, sir. Okay. So, for your CA Inter, it is not there. Just to make you feel good, I am just showing you this section, sir. So, 164 section mein, if you see, they are talking about disqualifications for appointment of a director. You have to respond, sir. Disqualification for appointment of a director, sir. That means who cannot be appointed as director is what this section is talking about. Ki bhaiya, tomorrow imagine Amara Chintu wants to become a director in a company. If Chintu comes under clause A, B, C, D, E like that up to I, sir, if at all he falls in such type of situation, sir, then we are telling company, please don't appoint this Chintu as your director. He cannot become a director, sir. Okay? Okay. Now my question to you people is, what are there in this point, sir? Let us see what are there in this point, sir. So if you give one plain reading, sir, a person shall not be eligible for appointment. Always remember, sir, if the word used are like this, not be eligible means you are disqualified. What's the word used? Not be eligible means you are disqualified. So a person shall not be eligible for appointment as a director of a company if he is of unsound mind. Sir, he is of undischarged insolvent. He has applied to be adjudicated as insolvent. Now here I am not interested in teaching all these points, sir. I just want to give your kind attention to this particular point. Dekho, everywhere what is the word used? he is the word used, sir. Now tell me, sir, imagine our Chinti is unsound mind. Okay, her treatment is going on in Eragadda hospital, sir. Now imagine, sir, Chinti wants to become a director of a company, sir. And imagine, sir, for example, sir, one of the employee of a company or one of the officer of the company says, board of directors, you cannot appoint Chinti as a director. Then Chinti is like, why you cannot appoint me as a director? I am also a human being. Definitely I will become a director, sir. Then that particular person will tell, I studied company law. In company law, what is the word used? He is the word used. Hence, sorry, in company law, disqualification is there. Here you are a person of unsound mind. Hence, you cannot be director. Then Chinti will say, I also studied company law. है ना? There the word used is he, but I am she. April Fool. है ना? Now I will definitely become a director. Is what her contention is, sir. Now tell me, sir, how to solve this problem? Now lawmakers, while writing, they did not think that matter will go like this also. What they thought, when I am writing he, they thought that he is also there, she is also there. But maybe sometimes while writing, maybe there could be some mistakes, sir. But now the question is, mistake to they made, sir. Now what should we do? How to solve this problem, sir? So can I say, if you go with Chinti's point of view, definitely what she is saying is right. If he is written, she is she, hence she should become a director. But tell me, sir, intention of lawmaker is achieved. Why did lawmakers tell that unsound mind person should not be a director? Logic is very simple, sir. He does not have capacity to contract. When you are a director of a company, there are n number of contracts which you have to do on behalf of company. That means for company also you will do, and somebody will do with the company also, sir. The question is, if you are the one who are going to enter into contracts on behalf of the company, you himself is who himself are not having capacity to contract, how you can allow company to enter into a contract, sir? So don't you think intention of lawmaker is this? What is the intention of lawmaker, sir? We never want any person who is not having capacity to contract to act as a director, sir. Yes or no, sir? Now tell me, sir, do you think you will be reading these words, or you will be reading, or you will be understanding the intention of lawmaker? Understanding the intention of lawmaker, sir. Are you there, sir? So as a judge, now what I will tell here, he should also include she. This is what I will be interpreting, sir. I hope this is understandable. Okay. To solve this problem, sir, also we have General Clauses Act, sir. So because of this type of problems only, there is something called what? General Clauses Act. So General Clauses Act may, it is clearly written, if you read section number 13, what is written? This is part of our syllabus, sir. General Clauses Act also. What is written? In any act. Read the second point, sir. Words including. No, second point I said, sir. Second point matlab. This point I am talking about, sir. In any act, words including or indicating masculine gender shall be considered to include females. Wow. Means General Clauses Act section 13 is telling you one rule for interpretation. In whichever law masculine gender is used, what is used? Masculine gender is used, definitely you should also include feminine gender, sir. That means now judge, when this issue comes to the judge, what will judge say? Mandabudhi advocate or Mandabudhi Chinti? Anyway, Chinti is Mandabudhi only. Unsound mind, no. So Mandabudhi Chinti, unsound mind person is not having capacity to contract, whether it is he or she. I am also using which section? Section 13 of General Clauses Act, sir. Are you understanding? Hence, this Chinti will not be qualified to become director of the company, sir. Are you understanding, sir? Similarly, imagine a scenario. So indirectly, one section of General Clauses Act is over. What is the section, sir? Section number 13. Section 13 talks about two aspects. One aspect I have covered. What is the one aspect? Whenever in any law, which gender is used? Masculine gender is used, you also have to include feminine gender, sir. So total contract act may, wherever he is there, she is also there, sir. But my question to you people is, imagine there is any law where she is only written. Matlab lawmakers have written a word she. Now imagine Amara Chintu says, he may, she came. Then she may, he should also come, sir. Now my question to you people is, do you think at that place, wherever she is there, he will also be brought up, will not be brought up? Bolo bacha. Then this is pakshapatam. ये अन्याय है फिर, है ना? If he may you brought she, then she may you should bring he, sir. ये तो गलत है गया फिर. How should we do this? Now again read section 13 properly. If you read section 13 properly, sir, उसमें first point what is written? Words in singular shall include plural. Means whichever law में singular word is used, you should read it as a singular also, and you may also include it as a plural. And what is the word used? And vice versa. What is vice versa? If plural is there, you can also include singular, sir. Now tell me, sir, when lawmakers for first point they have written and vice versa, for second point did they write and vice versa? No. Why? Ink over. While writing the law, whatever pen they were using, sir, that pen ka ink over. Bolo Raja, or they were lazy, or they had fight with the wife. Why? When they can write and vice versa for first point, they can write and vice versa for second point. They did not write and vice versa for second point because they did not want to write and vice versa for second point. Hence, what is the conclusion you should give? If at all she is there, then she will only be there. Who will not be there? He will not be there, sir. For example, you have something called Maternity Benefit Act. In India, we have a law called what, sir? Maternity Benefit Act. Obviously, you know what do you mean by maternity benefit, sir. So Chinti is expecting a Chintu, sir. She is about to become a mother, sir. So obviously at that time, law is saying that half years ka salary, who has to give? Employer has to give. To whom, sir? Chinti, sir. Half year salary. Wow. How many weeks are there in a year? Mandabuddhi. How many years are there in a year? 54. Very good, ma. 52 weeks are there. Uska half, 26 weeks. 26 weeks salary will be received by whom? Chinti for her maternity benefit. She need not come to the office, plus she can get the salary also. That is the labor law benefit, which who has given to whom, sir? Lawmakers have given to whom, sir? Women employees, sir. 26 weeks salary has to be given, sir. Now my question to you people is this. So Chinti anyway is getting 26 weeks ka salary, not at all a problem. Chintu comes saying that when Chinti is becoming mama, I am also becoming. Bolo bhaiya, Chinti becoming mama, I am also becoming papa. So mere ko bhi de do, hai na? To me also, you have to give me 20 weeks. If not 26 weeks salary, at least 20 weeks de do, discount le lo, 50%, 13 weeks you give, sir. Now my question to you, please. Chintu ka argument is correct or not correct? Obviously not correct. You have to understand the intention. Why we are giving, sir? Ki obviously she has to take care of herself also. At that point of time, health issues ka problems will be very, very high. Plus, it is not one life now. It is 2 lives. So she has to take care of that. Ab Chintu ka kya problem hai? Nothing is there, sir. So hence intention of lawmaker was this. Hence we does not want to include what, sir? He, whenever what is written? She is written. I hope this point is understandable. Now tell me, sir, can I say these are some tools which we are using for understanding law better, sir? This is the reason why we are reading 2 laws. One is General Clauses Act, one is Interpretation of Statutes. Are you understanding? Remember one point, sir. General Clauses Act is a law which is passed in India, sir. But Interpretation of Statute is not a law. In fact, this chapter is going to tell you some rules which you have to use for interpreting any law. And remember, these rules are used not only by India. These rules are used globally. Means whichever part of the land you are, whichever law you are reading, sir, that law may you will apply those rules which are given in Interpretation of Statutes. So Interpretation of Statute chapter is not only for interpreting which law? Indian law. It is for which law? All the laws. But yes, General Clauses Act is for interpretation of which law? Indian law, because it is a law which is passed in India, sir. I hope this is clear, sir. So hence what I will be doing is, first we will cover IOS chapter, then we will focus on General Clauses chapter, then we will focus on FEMA chapter, sir. Is this point understandable? So let's write down the heading as Interpretation of Statutes, sir. Heading is Interpretation of Statutes. interpretation of statute. And I would like to give one add-on also, sir. Interpretation of statute, document, and deeds. Okay, so better we will write this as the name of our chapter, sir. Even though textbook mate is written as interpretation of statutes, but you better write down interpretation of statute, documents, and deeds. Okay. So obviously 10 marks, average 10 marks you can say, sir. Now how we are going to read this chapter, sir? This chapter ko we are dividing into 4 parts, sir. So first we are going to understand something called rules of interpretation. We are going to read something called rules of interpretation, sir. Then we are going to read something called aids. Now aid is nothing but here help. Helps to interpretation. Helps to interpretation, sir. Now these two things we are going to read is for statute. Chinti non-stop talking, ma? This is for statute. Then we will read something called interpretation for documents and deeds. Documents and deeds. This is interpretation for documents and deeds. Third is interpretation for documents and deeds. Interpretation for documents and deeds. And fourth point is something called miscellaneous topics. So you have some 2-3 definitions, sir, which we are going to read. What do you mean by document? What do you mean by deed? You know, those type of topics are there, sir, which we are going to read in miscellaneous topics. If at all we give a quick glance to our chapter, sir, you will be finding 95% content is only 95% of the content. Imagine if this chapter is 30 pages, usme almost 25 pages are rules of interpretation, aids of interpretation, sir. Remaining these two constitutes only for 5% content, sir. Okay, so content wise, most of the content is your rules of interpretation and aids to interpretation, sir. Clear hai? Yes, chaliye sir, let's go forward. So in other words, we divided this chapter into 4 parts, sir. Okay, and we will go in this order only. First we will cover rules for interpretation, sir, then aids to interpretation, then documents and deeds, and then miscellaneous topics, sir. Okay, let us go forward, sir. Till now you did not see, in fact, if I go through last 10 to 12 papers, sir, never ever any question was asked from documents and deed, but that doesn't mean they cannot ask, sir. So we will go through that now. Now let us start what is there in this chapter, sir. So there are 2 ways in which you can understand this chapter, sir. One is line by line reading, sir. But if at all I do this, no, sir, definitely everyone will sleep in this class. Okay, so hence I have my own examples. First I will go through those examples and then we will open your textbook, sir. In fact, I will make you write summary notes also in your notebook, so that on the day of exam, even if you write that much, that is more than enough for your exam, sir. Clear? Now, most of the CA students go, if you ask, sir, this is the most boring chapter for them. Okay, na? In fact, if you see many YouTube videos also, faculties also feel very, very lazy to record videos on iOS chapter. Reason is very simple, sir. Section number is not there, content is not there, and it is pure theory. Okay, but if you ask me very frankly, sir, I love this chapter very much. Reason is, sir, you will be understanding the psychology, how a particular person has to Read, understand the law, sir. Okay. Now, first point, let us try to understand what do you mean by the word called interpretation. What do you understand, sir? Interpretation of law. What is interpretation? Bolo. Understanding the true meaning of the words which are written in the law. Sir, interpretation is nothing but what, sir? To derive. What is interpretation, sir? To derive. Derive what, sir? The meaning. To derive what, sir? The meaning. Meaning of what, sir? The words. Meaning of what? The words. Used in what? Used in the law. So, what is interpretation, sir? You have to derive the meaning. Meaning of what? The words which are used where? In the law. So that act of deriving the meaning to the words which are used in the law is called as interpretation. Write down first point, sir. So interpretation refers to the act of deriving the act of deriving the meaning of the words, the act of deriving the meaning of the words used in any law or used in the law. Okay. Now, sir, you will be also finding that sometimes in our textbook also the word uses construction. You will be finding interpretation word is also there, construction word is also there, sir. Sir, to be very frank, 99% or what you say, sir, almost interpretation and construction word is same. Minute difference is there, but at interlevel you can ignore it. Hence, wherever we are using a word interpretation, you can also say construction, sir. I hope this is clear, sir. Yes or no? So we will use these words synonymously. Which words? Interpretation and construction, sir. So interpretation of statutes or construction of statutes. But still I am telling you there is a minute difference, but at interlevel you can ignore. In fact, our textbook is also not showing that much interest in differentiating between interpretation and construction, sir. So hence, most of the rules which we are going to read very soon, we will do namkaran for that, sir. Name ceremony we will give for all those rules. There you will be finding sometimes they will use a word interpretation, sometimes they will use a word construction, sir. Synonymously they are using, we will also use it synonymously, sir. Okay, that is one point which I wanted to tell you, sir. Sir, interpretation, construction we are talking about, sir. Now question is, who will do this? Who is going to do this, sir? You are doing I am doing we are just reading kada. Who is really doing it, sir? Obviously, this will be done by whom, sir? Courts. So this interpretation or construction is something which has to be done by courts, sir. I hope this is point clear, sir. Okay. Now my question to you is, sir, if courts are doing interpretation, if courts are doing construction, then question is, when they will do? First question is, who will do? Second question is, you got the answer, who will do? Who will do? Courts will do. Question is, when they will do, sir? When they will do, sir? Obvious logic is, can I say there should be some dispute or there should be some case which is in front of whom, sir? Court. Yes or no, sir? Yes. Plus, there is advocate number one. Sir, he has given his viewpoint. Correct? So this is his point of view, sir. And there is advocate number two who has given his viewpoint, sir. So advocate one is saying, just up, law is saying like this. Advocate two is saying, just up, law is saying like this. Advocate one is nothing but what, sir? Plaintiff ka advocate. Advocate two is nothing but what, sir? Defendant, opposition ka advocate, sir. So both the advocates are giving their point of view to whom, sir? The judge, sir. Now can I say it is the judge, it is the court which has to derive the meaning. It is the court or judge which has to derive the meaning. In other words, judge or courts has to do something called interpretation or construction, sir. So that means if dash does not happen, dash is not required. Fill the dash. If dash does not happen, dash is not required. Now tell me, sir, if dispute is not there, interpretation is not required. If interpretation is not required, judges are not required. Yes or no? Police is required only if crime occurs. And more importantly, crime gets reported. Now you may be finding many situations where crime occurs, but crimes are not reported. At that time also, who cannot do anything? Police also cannot do anything. That means judges ka role will come only if matter is reported in the court, sir. A case is reported in the court and they are having two point of views. Imagine if advocate 1 is also saying same thing, 2 is also saying same thing, then there is no requirement of any interpretation, sir. Why? Both are understanding the intention of lawmaker in the same manner. Are you understanding, Raja? Bolo, then you should have written something, no? Second question is, who will do interpretation, right? No? First you wrote what is interpretation. Second is who will do interpretation. Who will do interpretations? Obviously courts or judges. Third, when this interpretation is required? When there is a dispute and there are two different point of views. When there is a dispute and there are two different point of views. Can I? Chaliye, sir. Let's go forward. Over a chapter over. Obviously, we have to discuss too many things, sir. Now, can I go forward, sir? Yes. Up. Let's understand. Obviously, you might be knowing, sir, how a law is passed in India. Parliament, then Prime Minister, Chief Minister. Sir, at one point of time, we will discuss that point also, sir. Now, let us continue our discussion. अब एक एग्जाम्पल आई विल टेल यू सर इंपॉर्टेंस ऑफ इंटरप्रिटेशन कि व्हाई इंटरप्रिटेशन इज रिक्वायर्ड. हिंदी में आई विल राइट, इंग्लिश में ट्रांसलेशन ऑल्सो आई विल डू सर. ओके ना, डोंट वरी. सो इमेजिन आई एम राइटिंग वन लाइन लाइक दिस. Now people who don't understand, sir, I am just reading what I have written. रोको मत जाने दो. रोको मत जाने दो. अब imagine a scenario. Sir, English is a funny language. In fact, every language में little bit of fun is always there, sir. अब imagine a scenario. Lawmakers have written this line. Imagine, sir. Just imagine the lawmakers have written this line. While writing this line, lawmakers have put comma here. Okay? रोको मत जाने दो. अब imagine a scenario, sir. हमारा चिंटू, while reading the law, he thought, comma only, no. What will happen? He put comma here, sir. Ab, my question to you people is, if you read this line, what is the interpretation you get, sir? And if you read this line, what is the interpretation you get? Sir, if you read this line is saying, roko mat jane do. Don't stop, let them go. What this line is saying, roko mat jane do. Stop, don't let them go, sir. Do you think complete meaning has changed? This is what interpretation can do, sir. Are you understanding? This is how people will play with the law. People will play with the law, sir. Are you understanding? Hence, there is a need for having a proper rules for what, sir? Interpretation. We have to avoid this type of situation. Otherwise, what will happen? Every advocate will twist the law according to his own wishes. Agreed or not, sir? And what we will be doing, sir? Clapping clone, sir, which we don't want. Hence, we have brought some rules for what, sir? Interpretation, sir. I hope this is understandable, sir. Okay. Before I start this chapter, sir, little bit of basics I would like to talk about, sir. Sir, do you think there is any difference between act versus law versus statute? बोलो राजा. चैप्टर का नेम इज इंटरप्रिटेशन ऑफ एक्ट, इंटरप्रिटेशन ऑफ लॉ और इंटरप्रिटेशन ऑफ स्टैच्यूट है ना. सो वी आर नॉट टॉकिंग अबाउट इंटरप्रिटेशन ऑफ एक्ट, वी आर नॉट टॉकिंग अबाउट इंटरप्रिटेशन ऑफ लॉ, वी आर टॉकिंग अबाउट इंटरप्रिटेशन ऑफ स्टैच्यूट. अब let us talk line by line, sir. Now tell me, sir, is act and law one and the same? Bolo Raja. Act and law one and the same. Maybe little bit of understanding you may be having. A question I will ask you, sir. Can I say we have something called Companies Act 2013? Word itself is saying I am a Companies Act. I am not a company law. I am a Companies Act. Obviously, this act was earlier a bill which was presented in the Houses of Parliament, which received the assent of President, which was notified in the official gazette, and then it was called as a act. Totally, it has somewhere around 470 sections. Okay, very nice, sir. Now, can I say by virtue of this act, central government is also having powers to prepare rules. You might have heard about something called rules, sir. So can I say act is also there? Rules are also there, sir. And in fact, if you see, sir, total Companies Act is divided into 29 chapters. It is divided into 29 chapters, and for each chapter there is a corresponding rule. For example, if at all I have to show you, sir, this is your Bear Act. Let's see, this is your Bear Act, sir. Bear Act means what, sir? What do you mean by Bear Act? Law as passed in Parliament. What is Bear Act? Law as passed in Parliament. Bear means what, sir? As it is. No additions, no deletions. How an act was passed in the Parliament, that act ko we give a name as Bear. Bear means उसमें कोई छेड़खानी नहीं किया. We did not make any changes. How it was written, like that only we are showing you. Okay, na? Whereas if you see Companies Act ka textbook which is given to you, no, we will not call that as Bear Act. Why? There ICA has taken luxury to make some changes, sir. They might have changed some words. Hence, it is not a Bear Act. It is like a Bear Act, but not a Bear Act, sir. I hope this is clear. So what is Bear Act? This is a Bear Act. Why? Sir, this is as passed in the Parliament, sir. So if you see, 29 chapters are there. See, what is the name of chapter number 1? Chapter number 1 is preliminary. This is what you were studying. Section 2, definitions. You were studying? No. Chapter 1 is preliminary. Chapter number 2, what is the name? Incorporation of companies and matters incidental thereto. Now, what did lawmakers do, or what we have prepared? What is the structure of Companies Act? Sir, what we have observed is, if everything we write in the act only, everything means what, sir? Every detailed procedure, if you write in the act, then size, content of the act will become very, very large. Bulkier it will become, sir. Hence, what did we do, sir? Substantive part we have written in act. Substantive part, mota means big part we have written in the act. Procedural part, what did we do? We wrote in the rules. Example, sir. Imagine if procedural part is also written in the act, what is the problem? I will tell you, sir. For example, sir, if somebody asks you, Anna, tell me how to withdraw money from ATM. Step by step procedure you tell. You also know, I also know how to withdraw the money, but we have to put it on the paper. Now tell me, sir, don't you think minimum 2 pages you'll write? Bolo, step number 1, one should have ATM card. Step number 2, he should take that ATM card. Step number 3, you should go to ATM machine. Step number 4, insert the card inside the ATM machine. Step number 5, wait for the dialog box to appear on the screen. Step number 6, act according to the dialog box. Now, don't you think conducting the activity was more easier than describing the activity? This is what procedural part can do. If this procedural part also I write in the Bear Act, just imagine the length of the section. Bolo Raja, length of the section, how big it will become, sir. Sir, isse what will happen? Details mein you will forget what is exactly to be read. Imagine, sir, main part is only 2-3 lines. But if it is described in 30-40 lines, no, you will forget what you are reading. Hence, what did we do, sir? To bring that clarity, substantive part, most important part, we brought in act and procedural part ko, instead of bringing in the act, in act only we gave a reference कि भैया procedural part है ना, for this you refer the rules. इसलिए act में words will be used as may be prescribed, as may be prescribed, as may be prescribed. Where it is prescribed? In Instagram, Twitter, where it is prescribed? In the rules. That means while reading the act, stand alone you cannot read it. You have to read in conjunction with rules. Are you there, Raja? Okay. Ab, my discussions starts from here, sir. Now question is, what is the difference between act? What is the difference between law? Ab, Companies Act is there. 29 chapters are there, sir. Sir, under Companies Act only, for each chapter, there are certain rules. For example, just now you studied preliminary. For that also there is a rule. Just now you studied incorporation of companies and matters incidental thereto. For that also there is a rules. The Companies Incorporation Rules 2014. Chapter 3 is talking about what, sir? Prospectus and allotment of securities. For that also there is a rules. Means for each chapter there is a corresponding rules. Say for example, sir, let us try to understand the Companies Prospectus and allotment of securities rules 2014. Okay, na? Like that rules are there, sir, and it is part of your syllabus, sir. Okay. Now my question to you people is, I am asking you one question, sir. Tell me, is Companies Act 2013 an act? Bolo Raja. Sir, yes or no, you have to respond. You cannot sit like this. Is Companies Act 2013 an act? Yes. Is Companies Act 2013 a law? Bolo Raja. Yes. For both the answer is yes. Companies Act 2013 is a act. Companies Act 2013 is a law also. Now my question to you people is this. Now this rules you wrote, this rules you wrote, no, Companies Prospectus and allotment of securities rule 2014. Is this an act? Bolo Raja. Is this an act? No. But is this a law? Yes. Then what you are trying to tell, sir? You are saying rules are law, but rules are not act. You are saying act is a act is also a law. By this, moral of the story is, law is a wider term. Law is a, which includes act. Which includes act. Are you understanding, sir? Remember one point, sir. Because of dash, dash came. Because of act, rules came. Are you understanding? Because of rules, act did not come. Because of act, rules came. That means first we prepared a substantive law. For that substantive law, we defined certain procedures. And that procedures ke liye we prepared a rules. Are you understanding? Somewhere some what is say running notes you should have written. Difference between act versus rules. Write down heading as act versus rules. So tell me, 470 section is what? It's an act. Write down, sir. For example, Companies Act में 470 sections are nothing but act. And bracket write down, what do you mean by act? A bill as passed in the parliament. What is an act, sir? A bill as passed in the parliament, sir. Okay. Then you may write, sir, Companies Act 2013 is act also and law also. Companies Act 2013 is act also and law also. Whereas rules under Companies Act. Now I am not writing any one rule, sir. I am saying rules under Companies Act. So this will include all the rules. Rules under Companies Act are not act, but they are law. Rules under Companies Act are not what, sir? Act, but they are law. But they are law. Hence, what is the conclusion? Scope of law is wider compared to scope of act. Scope of law is wider compared to scope of act. So law may only act will be there, only rules will be there, other things can also come. Other things can also come, sir. For example, imagine, sir, central government, time to time, they have to tell something in Companies Act. For example, can I say small company definition you might have studied? Yes or no? Which company is a small company? Which company is the kutti company? Chinti company, chota company. कौन सा company है छोटा company? चिंटू बोलो. That company is a small company which is not a public company. That company is a small company whose paid up share capital does not exceed 50 lakhs or such higher amount as may be prescribed, which cannot go beyond 10 crores. And whose turnover in the preceding financial year does not exceed 2 crores or such higher amount as may be prescribed, which cannot go beyond 100 crores. Yes or no, Raja? That company will be called as a small company. Okay. That means if you read the act, lawmakers have only given you some numbers. They said what, sir? Paid up share capital cannot go beyond 50 lakhs. But time to time it can increase, but it cannot go beyond 10 crores. Similarly, turnover cannot go beyond 2 crores, but it can be increased, but it cannot go beyond 100 crores. That means up today I have to determine which company is a small company. How I will determine? Bolo Raja, 50 lakhs is the limit. 2 crores is the limit. 10 crores is the limit. 100 crores is the limit. That means it is now the duty, or it is now the responsibility, or it is now the power of whom? Central government. Central government by issuing a notification. Central government by issuing a notification will tell you what is the limits. Will tell you what is the limits. Did central government tell the limits? Yes. Currently, they are saying what, sir? This limit is what, sir? 4 crores. And this limit is what, sir? 40 crores. That means what, sir? Any private company whose paid up share capital does not exceed 4 crores and turnover does not exceed 40 crores will be termed as a chota company for the purposes of Companies Act 2013. My question to you people is this. Sir, just now you said central government has issued a notification defining the limits for the small company. अब प्रश्न ये है, question is this, कि is this notification a Companies Act? Is this notification a Companies Act? Is it an act? No. But is it a rule? Yeah. Sorry. Is it a law? Yes. That means you have to follow this also. Are you understanding? So notification is not a act, but notifications are law. That means scope of law is wider than the scope of act. Law includes act, law include rules, law also includes notifications. Are you understanding? And remember, central government has got power to issue notifications. How this power came to central government? Because this power is given in act only. Means act itself has given power to whom? Central government to issue notifications. Are you understanding? If dash is not there, dash would have not come. If act would have not been there, then central government would have never received the power to issue notifications. Because of this only that came. Are you understanding? If act is a product, then notifications under Companies Act is a byproduct. Are you there, Raja? So next point also you write down, sir. Even notifications issued by central government. Even notifications issued by central government, even notifications issued by central government under Companies Act. Now, I am discussing examples of only Companies Act. That means this point is only for Companies Act or for any law. Any law. But because 70 marks we are reading, 60 marks we are reading Companies Act, I think better we will take example of Companies Act, sir. So notifications issued by central government under Companies Act are also part of the law and not act. They are not act, they are law. Okay, Raja. Next point, sir. Sare. Next question, sir. Can I go forward? Yes. Now, sometimes what will happen, sir? Now, tell me, sir, Companies Act is there. Who is the administrative body for Companies Act? Can I say you studied something civics mein legislature, executive, judiciary. Legislature. What is the job of legislature? Organs of government. 3 organs of government. Body mein many organs are there, no? Government ka 3 organs are there, sir. Legislature, executive, judiciary. Legislature is what I mean by lawmakers. Are you understanding? Legislature, to legislate the law is to prepare the law. Member of Legislative Assembly. What that Dund will do? Those MLAs, what they will do, sir? They are the one who will go to Legislative Assembly, no? That means they are the one who are preparing the law. So that means whomever you vote, no, you should see whether that Dund has that much knowledge also. Most of the people, they don't know what is there in the bill also. Bas oppose karna hai, okay, we will oppose. Okay, we have to let it pass. Okay, we will vote in favor, sir. है ना? Sir, sad state of affairs. But anyway, now tell me, sir, Companies Act 2013 is there, sir. Now, I was just telling, I forgot what I was talking about, sir. Legislature. Then there is something called executive. Executive means what, sir? Legislature has prepared the law. But can I say somebody has to follow the law? Bolo Raja, Papa had paid the fees. Now can I say you have to go to school also? है ना? So now somebody has to follow the law. So there is one organ of government which will ensure that people are following the law. That organ of government we are calling as executives. Or you can say they are administering the law. They are administering the law. Remember, Companies Act 2013 is not legislated by Ministry of Corporate Affairs. Are you understanding? MCA never prepared which law? Companies Act. MCA is administering Companies Act. Are you understanding? Nirmala aunty is there, no? Nirmala aunty prepared the law, or Nirmala aunty is ensuring that law is properly implemented? She is ensuring that law is properly implemented. Why she is not preparing the law? Logic simple. Audit studied. I only prepare, I only implement. Then what will happen? I may abuse my power. Internal check. Chartered accountant. Audit you will do in future. Why? All the power should not be given to one person. If all the powers are given to one person, he will abuse the power. He will abuse. Correct, Raja? You only prepare question paper. You only write the answer. You only do correction. What will happen? 100 marks ko 105 you will get. 5 marks for good handwriting. Apsara. Are you understanding? Hence, person who prepares the question paper, person who writes the answer, person who corrects the paper, all three are different people, sir. We don't want that collusion, sir. If that collusion comes, then obviously fraud will happen. But that is different thing. India mein, we are divided by religion, united by corruption. Yes or no, sir? जैसे corruption matter comes, no, we don't see Hindu, Muslim, Sikh, Isai. Sab bhai bhai hai. But on all other matters, we will fight on the name of what, sir? Religion. That is some other day we will talk about it. Now, Companies Act mein, we are talking about who is administering. Then obviously it is Ministry of Corporate Affairs. Similarly, can I say if it is Income Tax Act, who is the administrative body? Oh, Income Tax Act is over, guys. Sir, CBDT. Heard about this? Central Board for Direct Taxes. CBDT is the administrative bodies. Now, my question to you people is this. Sometimes Ministry of Corporate Affairs, sometimes CBDT. Sir, these people will issue some clarifications. These people issue from clarifications, or these people issue some circulars. Now, what do you mean by circulars? What do you mean by clarifications, sir? Let us take some examples. Now, imagine a scenario. I am the company secretary for TCS. Okay, na? Group company secretary for Tata Consultancy Service Company, sir. Can I say very big company? So obviously, law ka compliance I have to do, sir. Companies Act ka compliance I have to do, sir. Now imagine a scenario. I am complying any particular provision of Companies Act. Now, when I am trying to read or when I am trying to understand the law, sir, I myself are getting, or myself I am getting, sir, two to three viewpoints. Means I think law is trying to tell like this. I am also thinking, no. It is trying to tell like this. In other words, I am confused. Ki what is really the intention of lawmakers, sir? As a problem I am having, sir. So as a company secretary, what should I do now? Maybe I can talk to some other company secretaries. Possible, Raja. If I am one practicing chartered accountant, if I am having some issue in interpreting a law, what I will do? Bolo Raja, I may take help of another CA. Now imagine that Dund is like, oh, like that also you can think. He never thought in that manner, sir. Are you understanding? So that means what, sir? Now I have put a new seed for what, sir? Confusion in his mind, sir. So leave that particular person. Imagine like that, I went to 10 to 15 company secretaries. Everyone is having their own point of view, sir. Now tell me, sir, big company like mine, imagine tomorrow, if I comply this in a wrong manner, it will amount to non-compliance. And don't you think Nirmala aunty eagerly waiting? Bolo Raja, non-compliance ikkada, penalty akkada. So can I say both effect and consequence, both will happen at the same time. Time also she will not give, sir. Now my question to you people is, do you think I should wait for non-compliance ka penalty to be levied on me, or I want to comply this law in a proper manner? I want to comply this law in a proper manner, but I am having a confusion what to do. So hence you also have this facility, sir. What is the facility? If you are having this type of issues, you may write a letter to whom, sir? Ministry of Corporate Affairs, saying that while reading this particular section, we are getting two point of views. This is one point of view, this is another point of view, and this type of issues or this type of problems many assessees are facing on grand scale, sir. Then who wrote letter to whom? The TCS ka company secretary has written a letter or application to whom, sir? MCA, sir. Then MCA may issue a clarification. MCA may issue a circular saying that, Raja, you have to read like this and not like that. Are you understanding? My question to you people is this. MCA clarification given, are bolo? MCA circulars issued, yes. My question to you people is this an act? Is this a law? It is a law and not the act. Are you understanding? Why? It is not passed in parliament. It is not passed in parliament. Remember, anything passed in parliament is an act. Other than parliament, still you have to follow, then it is a law. Are you there? Write down next point. Clarifications or circulars. Do you think MCA will issue circular only if you make an application, or sometimes on suo motu basis also they can issue? Suo motu basis means voluntary basis. So either you make an application or you don't make an application. Can I say sometimes when all are facing the problem, I may also know this. Bolo Raja, Nirmala aunty may also knowing this. Many companies are facing problem. I myself are not understanding. So suo motu basis also who can issue the circulars? MCA can issue the circulars. MCA ko generally we call as department. We call as what, sir? Department. But saying that when I say department, not police department. Department means Ministry of Corporate Affairs. So who may also issue circulars or clarifications, sir? Department. Clear? And how they will do? Maybe upon your application or on suo motu basis. Are they an act? No. But are they law? Yes. Why? Again, logic is simple. Because of act only they came. Dash not there, dash not there. Act not there, circulars or clarification would have not been there. So write down, sir. Any circulars or clarification issued by ministries of corporate affairs under Companies Act, Ministry of Corporate Affairs under Companies Act, is not an act, but is not an act, but what? It's a law. वो law है. Done, guys? Now tell me, sir. Scope of dash is dash then dash. Scope of law is wider than the scope of whom, sir? Act. Now tell me, till now, what things are there in law? Act is there, rules is there, notifications are there, circulars or clarifications are there, sir. You know, horrible, nice, sir. More I have to tell, sir. Now tell me, sir. Can I say tomorrow, if there is a dispute in any provisions of Companies Act, matter went to the court, judge has given one opinion. So do you think next time when similar type of facts occurs with you, similar type of dispute occurs with you, you have to comply with that judge ka opinion? Bolo Raja? Yes. There is a reason most of the time income tax mein you studied case laws. In so and so case law this was decided. And don't you think that also has become a part of your law and not part of act? Are you understanding? So all those judicial pronouncements or case laws are also part of the law but not part of the act, sir. So write down. All judicial pronouncements. Pronouncement means what, sir? Declaration, which judge do, sir. All judicial pronouncements, bracket में write down, that is case laws. All judicial pronouncements, bracket में write down, case laws are also part of law. Are also part of law. Clear, Raja? Bracket में down, but not act. But they are not act, they are part of law. Okay, very good. Audit started. Audit report who will prepare? Auditor will prepare. And do you think audit report may we have to do some reporting? SA 700. Sir, no problem. Do you think something called CARO you heard about? Did not heard about CARO? Sir, no problem. For certain types of companies, there are some categories of companies, sir. Obviously, when your audit, sir, when he start talking about it, he will tell you which type of companies. For certain type of companies, central government has issued an order. Saying what, sir? Ki auditor, and this order is applicable for whom, sir? Auditor. What is this order saying, sir? Auditor Raja, this is a special type of company. Only normal reporting will not suffice. You have to report on all these matters. Which matter? All those matters are also described by whom? Central government in that order. They told fixed asset पे pass one comments, loans पे pass one comment, है ना? कि if the loan is used for long term purposes, is it used for short term purposes? Yes है, तो pass one comment. Like that, different items. Who told to whom? Central government by writing one order has told this to whom, sir? Auditor, sir. So even that order is also a act law. It's a part of the law. So we call this order as CARO. What do we call this? CARO. What is CARO, sir? Company Audit Report Order. Companies Audit Report Order. This CARO is also a part of law, but not act, sir. Clearer? So write down, sir. Any orders. Remember, even this order is also issued by central government. Any orders issued by central government under the act any order issued by central government under the act is also a law. Is also a law. Is also a law. Right? Next. Sir, now FEMA chapter I will start, sir. FEMA may sometimes we will use a word rules, sometimes we will use a word regulations. Oh. Sometimes we'll use a word rules, sometimes we'll use a word regulations. This is a rule, this is a regulation, like that I will use a word, sir. अब क्वेश्चन ये है रूल क्या है, रेगुलेशन क्या है ना. नाउ रिमेंबर इन फेमा मतलब while passing the law, parliament has decided like this: on these matters who will have power to issue notification. Then if this power is given to central government, then we will say whatever central government issues, we will call that as a rule. But if this power is given to whom, sir? RBI. Whatever RBI issues, we will call this as a regulation. Are you understanding? That means what, sir? Even regulation is also a part of dash, but not dash. Regulation is also a part of law, but not part of act, sir. So write down regulations issued by concerned authorities. Concerned authorities are also part of law. Regulations issued by concerned authorities are also part of law. Okay. A question I would like to ask you, sir. Tell me, sir, if 470 sections you study properly, tomorrow can you manage TCS company? Well versed you are. मतलब night में any section, any page, any number I tell you, sir, you are able to tell it, sir. Can you manage TCS properly, sir? Answer is no. Why? It's a listed company. If it is a listed company, you have to follow Companies Act plus SEBI regulations. That means what, sir? Who has given power to SEBI to issue regulations? Parliament. Parliament itself has given what? Powers to whom? SEBI to issue regulations. Are you understanding? So even SEBI regulation is a law. So if I am a company, I will follow rules given by central government, and if I am a listed company, I will also follow regulations issued by SEBI. Are you understanding? Pragmatic example: SEBI regulations under Companies Act. SEBI regulations under Companies Act. Are you understanding? Now tell me, sir. Give me the final picture, sir. Bolo bacha. Can I say act and law? Tell me. Act may what is there, sir? Can I say act may you will have what, sir? Only bare act. Law may what will be there, sir? You will have something called bare act. So you may write this as a conclusion. You may write this as a conclusion, sir. So act may bare act is there, sir, but law may bare act is there. Then rules are there. Yeah, rules slash you can say regulations. Then you will also have what, sir? Notifications. Then you will have clarifications, or you can call this as Bolo Raja, circulars. Then you will have judicial pronouncements, which is nothing but case laws. Even that is also a law. Then sometimes orders are also issued. Now, do you think whatever is the act which is prepared, lifelong it will be same? Sometimes it can be amended also. So bare act, including amendment act. Bare act, including what, sir? Amendment Act. Bare Act, including Amendment Act. Oh my God. Corporate law we are reading. Corporate act we are not reading. That means all this will come. Are you understanding? If it was just 470 sections, no, we would have completed in 20-25 days. Companies Act, totally I am talking about. But it is not just 470 sections. We are reading the law. This is how, or this is why our law becomes complicated. Why? You have to read all these things to get a full picture, sir. Are you understanding? Sometimes what will happen? First 20 minutes of the movie, if you read, no, or sorry, if you watch, then you will form one opinion. But once you watch the complete opinion, once you watch the complete movie, your opinion may change. For example, Triple R. Can I say Ramcharan? Can I say first 25-30 minutes if we see? No. Sir, we felt like killing him there only. Yes or no? But once we saw the bigger picture, then we understood कि अन्ना का goal is more bigger than Junior NTR. Yes or no, sir? So this is what it is. When you read a law also, sir, do not try to form opinion just by reading few sentences. You have to read law as a whole. You have to read law as a whole and then come to an opinion, sir. I hope this is clear, Raja. Okay, done. Did you write everything? Chaliye. Actually, what was our question, sir? Act versus law versus statute. Ab question hai, act we have understood, law we have understood. Now question is, what do you mean by statute? Then my answer is very, very simple. Whatever is a law, you also call this as a statute. You also call this as a statute. That means interpretation rules, are you applying only to act? No, you are also applying to whom, sir? DARE Act. You are applying to whom, sir? Rules, regulations, notifications. Everywhere these rules are used, sir. Is this point clear, Raja? So write down. Niche small point you write down, sir. Law is equal to statute or statute? Statute. It is not statue. Some people will write spelling as statue only, sir. So remember, it is not statue, it is statute. So law is equal to statute. In other words, interpretation of all these things we have to read and understand, sir. Clear, Raja? Chaliye, sir. Okay. Shall we go forward? Yes. Now let us try to discuss further points, sir. Okay. What are the things we have to study, sir? Agenda mein we have 4 agendas. One is rules. One is aids to interpretation. Third is documents and deeds. That is interpretation of documents and deeds. And fourth is miscellaneous topics. First, let us try to focus on 2 parts. Okay, na? Main parts let us focus, sir. One is your rules of what, sir? Interpretation. Rules of interpretation. And second, we will talk about what, sir? Aids. Aids ko you will also call as what, sir? Helps to interpretation. Okay, now sir, ये जो rules है, these rules are further divided into 2 parts. You can write along with me, sir. So this is the topic which we are discussing now. Rules of interpretation. It will come like this, don't worry, sir. Rules of interpretation. Now these rules are further divided into 2 parts. One we have is primary rules of interpretation. Primary rules of interpretation. One is primary means second will be secondary. Very good, sir. Secondary rules of interpretation, sir. One is primary and another is secondary, sir. Primary rules of interpretation, secondary rules of interpretation, sir. Now, if you see our textbook, sir, you will be finding 6 primary rules are discussed. How many, sir? 6. Obviously, I will not write the names now. This is what we have to study. generally my habit will be like this. First, I will prepare the framework. This is the framework. And now we have to fill the framework. In reading the answers, we will fill the framework. So by this, what will happen? Answer is understood. This framework will also get solved. Okay. So these are the 6 primary rules we have to understand. Okay. Very nice. Now, secondary rules. As such, secondary rules are many in number, but obviously everything we cannot cover. Max to max, we have to ask for how many marks this chapter? 9 to 12 marks, sir. And so obviously all secondary rules cannot be covered. So our ICI book mein, we are only covering 2 secondary rules, sir. But bonus mein, I will teach you one more also. So totally 3 we are going to read, sir. Okay, na? ICI book mein only 2 are there, sir. Okay, done. So we have, you may write like this, put underline also. Once this entire rules are over, no, you will come and fill this. So primary rules 6 are there. Leave sufficient gaps, sir, so that it doesn't look congested. So 6 primary rules, 2 secondary rules. Okay. Now we have something called helps to interpretation, sir. What do you mean by help to interpretation, sir? Now, example I will tell you, sir. Again, these helps are of 2 types. First, let us see this thing, sir. One is internal help and one is external help. Internal help ko you can also call as internal aids to interpretation, and next is external aids to interpretation, sir. That's it. 95% of the content will get over. If this 4 paras we are covering, sir. So primary rules, secondary rules, internal aids, external aids. Okay. Let's understand line by line all those points, sir. Primary rules. Why they are called primary rules? Reason is, whenever judge is doing interpretation, whenever, sir, you should keep yourself motivated. Your exam dates have come. Till now, what you were thinking, people are having, still, your seniors were writing the exam. Now it is your exam. Your dates have come. Yes or no? Yes. Come on, guys. Very soon you have to write it. Now, why they are called primary rules? Primary means whenever judges are doing interpretation, they will definitely follow. They will definitely follow either of the rule for interpretation. Primary mein. 6 are there. So they may follow either rule 1 or they may follow rule 2, rule 3, rule 4, rule 5 or 6. That means judges will definitely follow primary rules. Okay. But whenever we are talking about secondary rules, that means it is not must for a judge to follow secondary rule. It is his discretion. Discretion means it's his choice. Whether to eat veg or non-veg is your discretion. Nobody forces you, sir. It is choice of a particular person. I don't eat non-veg. It is my choice. Did anybody force me? No. Similarly, you eat non-vegetarian. That is your choice. Nobody forced you. That means it is your discretion. You may eat, you may not eat. In the same manner, judges may follow, may not follow. Which rules? Secondary rules. Okay. Sometimes you will also find like this. When a judge is using any primary rule, he may use primary rule in conjunction with any secondary rule. That means what, sir? See, at the end of the day, what we want, intention of lawmakers should be achieved. What we want? Whatever lawmakers wanted to achieve, we want to help them in achieving that. So if intention of lawmakers can be achieved by mixing one primary rule with another secondary rule, judge may also go to that extent also, by which they will follow primary with secondary. Are you understanding? By this, what is the moral of the story? Moral of the story is primary rules are not mutually exclusive. Secondary rules are not mutually exclusive. Primary, secondary is also not mutually exclusive. What do you mean by mutually exclusive? If Peter Parker is there, Spider-Man will not be there. That is mutually exclusive. Are you understanding? Both characters cannot be there at the same time. That is what I mean by mutually exclusive. What is not mutually exclusive? Both characters can be there at the same time. That means judge can follow one primary rule in conjunction with another primary rule, one secondary rule in conjunction with another secondary rule, or one primary rule in conjunction with another secondary rule, sir. I hope this is clear, Raja. So this understanding you should have written. Everything I will not dictate. And whatever you have understood, write down, sir. Why it is called primary rule? Why it is called primary rule? Primary rule is called primary rule because judges always will follow these rules first. At first instance, we will always give priority to these rules and not to secondary rules. But is it must for a judge to follow secondary rule? No, it is his discretion. That is the reason they are called secondary rules. So it is a discretion of a judge whether to follow or not. Hence they are called secondary rules, sir. And are these rules mutually exclusive? No. So judge, while interpreting any law, may use two or more primary rules or primary rules with secondary rule. Okay, na? Now, this point which I told you, is applicable for everything except rule number 1. That's the reason if you see 2, I have matched with 1 there. 1 I did not put, sir. Now, details I will not tell you now, sir, because if I tell everything in details, no, you will unnecessarily get confused. Just slowly we will read, you will understand, sir. Okay. So whatever you wrote, this is a general point of view, sir. Usme little exception we will add later. Okay. So these rules are mutually exclusive or not mutually exclusive? Not mutually exclusive, sir. Okay. Then up to here things are clear? Chaliye, sir. Then let's go forward, sir. Helps to interpretation, sir. Let us take example, sir. अब imagine a scenario, sir. Any particular section we are reading, sir. Say for example 20 section, 21 section. Just take randomly, I am telling you, sir. So we are reading a particular section of Companies Act. That particular section में holding company word is used, subsidiary company word is used. Now judge को एक doubt आ गया कि what do you mean by a holding company? What do you mean by a subsidiary company, sir? So do you think how judge can come to a conclusion? How can judge derive the meaning of a particular word used in the law? So do you think if at all I want to find out the meaning of holding company, do you think judge can use section 2 of Companies Act? Bolo Raja, imagine any random section I am telling you, sir. Say for example, I am reading section 40 of Companies Act. एक particular word is written in Companies Act. That particular word के ऊपर doubt is there now. कि what is the meaning of that particular word? So do you think to remove that confusion, to understand that word properly, do you think judge can use section 2 का definition? Bolo Raja. Can they use? And do you think if they use this definition, judge will come to a proper conclusion? So do you think this definition is acting as a help to whom? Judge, while doing interpretation. Are you there? So this definition is acting as a help. Help to whom? Judge, while doing what? Interpretation. So definitions are acting as aids. Definition acting as aids or helps. Now, just a violent guess you make, sir. Is this an internal helper, external helper? Bolo Raja. Though I did not teach you anything, sir, but chalo ek है ना दूर दृष्टि we will have. Is it an internal helper, external helper? Obviously internal help. Why? Simple logic है. Which law में confusion is there? Companies Act. Which case has come to judge? Companies Act का case has come. What he has referred to solve the problem? Companies Act only. Hence it is a internal aid. Are you understanding? Similarly, imagine any particular law is there, sir. Imagine dash act dash year. Companies Act 2013. No, I am saying any law. Dash act dash year. In this law, the word goods are used. What is the word used? Goods word is used, sir. Ab judge what he is doing, sir? He wants to know what do you mean by goods. Ab judge what did he do? He referred the entire act. Section 2 also he studied, sir. But nowhere he found the definition for goods in that particular law. Ab judge ko confusion aa gaya ki bhaiya how to derive the meaning. So what did he do? He also studied other laws. Hence he saw that there is a law in India which is Sale of Goods Act. In Sale of Goods Act, section 2 में they have defined goods का definition. So judge is now using the definition of goods given in Sale of Goods Act to get to solve the interpretation problem of this act. Now tell me, sir, do you think definition given in Sale of Goods Act is acting as a help for a judge to remove the ambiguity which is caused in interpreting this law? Yes, but is it an internal helper, external helper? External help. हो गया matter. Now tell me, what do you mean by internal aid? While interpreting any law, while if you are referring the act itself, if you are referring the, then it is called as internal aid. But if you are referring anything other than that act, anything, then that is a external aid. Now tell me, case laws are, case laws are, case laws are. My question to you people is case law an act? Bolo Raja, I told you what, if you are referring to law itself, if you are referring to act itself, I told referring to act itself. So case laws are always external help. Case laws are always external help. Are you understanding? So likh do. What do you mean by internal help? Right down. What is internal aid, ma? while doing interpretation, while doing interpretation, if one refers to, while doing any interpretation, if one refers to the act itself, one refers to the act itself. Which act, ma? Which act you have to refer? For that act where issue is there. Are you understanding? I'm not talking about every act. I'm talking about which act का issue is there. That act का issue को solve करने के लिए you are using the same act. Then that is called as internal. So while doing the interpretation, if one refers the act itself in which issue arises, in which issue arises, then it is an internal aid. Then it is an internal aid. नीचे downward arrow you may write down, for example, if there is any issue in referring to any provisions of Companies Act, for example, if there is any issue, for example, if there is any issue in referring, if there is any issue in reference of any provision of Companies Act, then one can refer to, then one can refer to definitions. One can refer to what, sir? Definitions, comma, explanations, schedule, definition, explanation, schedules of Companies Act. Now only three are, other things are also there. Other things are also there. But I told you, we are discussing in detail, overview we are getting a overview, sir, of Companies Act. These definitions, schedules, explanations are internal aids. Continue. These definitions, explanations, schedules are what, sir? Internal aids. So all these are internal aids. Okay, na? External aid. Now you come to external aid. External means outsider. So imagine family problem is there. Family people are only solving. Internal, sir. Sir, neighbor people coming. External, obviously. So external aid, right on, sir. While interpreting any law or while interpreting any act, while interpreting any act, if definition given in other laws, while interpreting any act, if while interpreting any act, definition given in other act is referred, then it is an external aid. Then it is an external aid. Okay, na? So what is the meaning of external aid, sir? All those tools which you are using other than the act itself is a external aid. So write down, sir. That is, all the tools which are used, all the tools which are used by the courts all the tools which are used by the courts to remove the ambiguity of a particular law, to remove the ambiguity of a particular law, to remove the ambiguity of a particular law. All the tools of other laws, you write, sir. All the tools of other laws used by the court to remove the ambiguity of a particular law are external aids. Are external aids. Is this point clear, sir? Example you can write down. What is the example of external aid? Imagine a particular word is not defined in particular act. For example, he includes she. Ab Companies Act mein he is there. I want to know whether he is only he or she also. Hence, what did we refer? Which section? 13 of what? General clause. So at that time, is it an internal aid or external aid? So it is external aid which has helped in removing the ambiguity, sir. So write down, sir. So these are called external aid. Example, definitions in other laws, case laws, dictionary meanings, dictionary, etc. Details we will see later on, sir. Up to here, things are clear. Did you understand everything what we are going to? Did you find anything boring in this particular topic, sir? No. So, framework is ready. What is ready? Framework means 6 primary rules, 2 secondary rules, internal aid, external aid. This will cover 95% of the syllabus of which chapter? Interpretation of statutes. Obviously, this we will take after the break, sir. But before that, I will just show you what are the names of those 6 rules. What are the names of those 6 rules? So if people are having the study material, you can come to study material 2.9. Rules of, you can see here, did I say differentiate between interpretation and construction? Using it synonymously. Synonymously. They wrote slash. Then you will see what is written here. Primary rules, secondary rules. How many are there? Now, you will be finding, if you see like this, no, you will find 7 are there. They go 1, 2, 3. Now, for me, they both are same. 4, 5, 6. Like that numbering you can do, sir. Don't write in the notebook. Okay, not textbook only, sir. And then we have 1 and 2, sir. So some rules while reading, no, you will find key reference is very, very differently, sir. Reason is Latin words they are. Doctrine of nocitur a soci. Then doctrine of contemporanea exposito. Okay. Then you have doctrine of ejusdem generis, doctrine of exceptional construction, beneficial construction, Hayden's rule or mischief rule, harmonious construction, reasonable construction, and literal rule, sir. And a rule of litera legis. This literal rule, called Latin name is what, sir? Litera legis. So all these 6 rules, including other 2 rules, we will discuss after the break. Thank you very much, sir.